Shall we start over? Okay. Good morning, Global Aviation family members. Good morning. I hope that you had a wonderful day at day one here at 2024 ICAO Legal Seminar. It's now time for us to brightly start the morning, the day two. Well, this is an event that is hosted by ICAO as well as the Korean Ministry of Land, Infrastructure and Transport. My name is Shin Ji-ye, serving as the MC for you, starting from yesterday until today. Well, let me remind you that this seminar is a paperless seminar, which means that we're providing all the presentation documents through the QR code that has been printed at the back of your name tag. And today we will be going through the session 3, 4, 5, and end the day with the closing ceremony. So I hope that you will be here with us until the very end and have a meaningful time here with us. Well, having said that, we're going to now begin the session 3 on the topic of facilitation. As mentioned yesterday, this year, 2024, has been marked as the year of facilitation. I think there will be a lot of abundant things being discussed through the session. So let's bring the moderator up to the stage. This session will be moderated by Mr. Alessio Quaranta, the President of European Civil Aviation Conference. Please give him a big round of applause. And of course, we will be joined by 4 spectacular speakers today. First of all, let's invite to the stage Mr. Andrew Oppola, the legal officer at ICAO. Welcome. And next, let me introduce to you Ms. Leslie McIntoshey, the Corporate Secretary and Acting General Counsel of IATA. Welcome. And now it's time to call upon Mr. Cho Young-ju, the partner attorney at law firm Lee & Co. And as for the last but not the least, we have Ms. Erika Barga, the legal officer from the Legal Affairs and External Relations Bureau at ICAO. Welcome. And now I'm going to leave the floor to the moderator.
Thank you very much and good morning, everybody. First of all, let me thank once again ICAO and the Ministry for Land, Infrastructure and Transport of the Republic of Korea, first of all for inviting me today for moderating this very interesting session, but also for the lovely dinner offered yesterday. It was very, very nice. And of course, it is a true honor for me to be here today and to lead such a stimulating discussion on the topic of facilitation. The goal today is to examine the topic of facilitation from different perspectives in the legal key, creating an inclusive, informative, and respectful conversation in which everyone can contribute their experiences and perspective. Before we dive into discussion, I would like to make a few remarks about the panel format. During this session, we will have the privilege to hearing a presentation from our distinguished speakers already presented before, each of whom will bring a unique perspective on the topic we are addressing. These presentations will provide us with a valuable opportunity to deepen our understanding of facilitation and to examine different angles and points of view. At the end of all presentations made by our speakers, there will be a Q&A session, which will be an important interactive moment and will allow for exchange of knowledge and further exploration of the topic discussed. But now, let's explore the concept of facilitation in more depth. In the field of civil aviation, you know better than me, facilitation are those activities, resources, and procedures implemented to make the movement of aircraft passengers and goods through airports smoother and less burdensome, while ensuring compliance with national and international regulation and standards. Specifically, facilitation are realized by the continuous improvement of control processes and service procedures. They require cooperation among the different sectors of the community, each of which operates under its own responsibilities and competencies. And facilitation, of course, involves mainly four groups of stakeholders: states, aircraft operators, airport operators, and of course, customers. And effective management of air transport facilitation improve aviation services quality and cost effectiveness, boosting civil aviation overall. Facilitation activities contribute significantly to development and have a positive economic impact. Facing new challenges, facilitation are essential for delivering adaptable, responsible, notably evident during events such as, unfortunately, the COVID-19 pandemic, or in preventing emerging threats in security or immigration, such as terrorism or human trafficking. Proactive actions by all stakeholders are necessary to ensure the resilience of systems, processes, and technology. Furthermore, over time travel itself has become an experience, whether we are taking about a journey with leisure purposes, work, or necessity. Therefore, new needs have arisen in order to perceive the travel experience as increasingly enjoyable, safe, and inclusive. Just think of increasing efforts aimed at meeting the needs of passengers with reduced mobility or with disabilities. In the context of civil aviation, facilitation also involves a series of legal aspects, including the management of biometric data, privacy, and data protection. The use of data and digitalization can improve the efficiency and security of checks and border processes. However, it is essential to ensure that the collection and use of such data respects passengers' privacy and comply with data protection regulation. The standard and recommended practices on facilitation outlined in Annex 9 to the Chicago Convention have been instrumental since the adoption in 1949. And this year marks the 70th anniversary of Annex 9, which has been reminded to us several times yesterday. Recognized by ICAO Council as the year of facilitation. After 75 years, facilitation system is gaining increasing importance considering both technological progress and the challenges faced by civil aviation from various perspectives. Furthermore, the increasing number of flights and passengers are expanding the audience using airplanes and airports. This, along with the rising average of the population, mobility and health-related issues associated with this phenomenon make the topic increasingly relevant. Annex 9 covers a broad spectrum of topics linked to aviation, requiring collaborative efforts among various stakeholders, including those not directly involved in the aviation sector, such as customs, law enforcement, and public health authorities. This is the reason why the celebration of the Year of Facilitation may contribute to elevate the attention by other stakeholders of government outside the aviation domain, providing for improved collaboration and implementation nationally. Now, let's move on to listen the valuable perspective of our speaker on this crucial topic. And we welcome as the fifth speaker, who will guide us through the legal milestone in air transport facilitation during 75 years. Mr. Ender Opolot, the legal officer, Legal Affairs and External Relations Bureau of ICAO. Mr. Opolot graduated with a Bachelor of Laws degree from Makerere University in Kampala, Uganda, and is admitted to the Ugandan bar. He obtained an LLM in Air and Space Law from the University of Leiden in the Netherlands. He worked for over 10 years as Chief Legal Advisor for the National Civil Aviation Administration of Botswana, and now he handles various portfolio on ICAO works in the legal field, among others, aviation security, including cybersecurity, air transport policy, conflicts of interest in civil aviation, environmental protection, and climate change and global air law training. Please, Andrew, the floor is yours.
Good morning, everyone, and I'm happy to be here again for the second time in 2 days. Thank you, Alessio, for the introduction. I think you made my work much easier by introducing the topic. Facilitation is, I like to think of it as a third pillar of international civil aviation. It is less discussed generally compared to aviation security and safety, and it's therefore most timely and fitting that it is included in the program for today for the first time at this event, at least for the last 10 years since I've been aware of it. And this is notable because facilitation is about laws, rules, and regulations for entry into a state and departure from it. Today, the aviation sector handles almost 100,000 flights a day, transporting about 12 million passengers and 20 billion worth of goods. And this presentation will highlight the various legal tools in air transport that have served the objective of helping people and goods move around the world and thereby empowering economic growth for the last 75 years since the adoption of Annex 9, as you've heard, on 25 March 1949. But first, to remind ourselves what is facilitation. And I'll start by talking about the movies. Are you familiar with the documentary Border Security? Anyone? Not quite. You can look it up afterwards, but Border Security is a riveting TV documentary that follows the Canadian and US border services officers as they process people and goods at international airports. Some of the action takes place at Vancouver International Airport, where 20,000 people get into Canada every day. And so this documentary gives you an inside look into how the frontline officers from border services apply facilitation rules in the task of separating genuine travelers and genuine goods from those that are not. I recommend for you to watch Border Security. More formally then, going to the definition of facilitation. Facilitation, as you've heard from Alessio, is concerned with ensuring or enabling the efficient movement of aircraft, crew, passengers, and cargo into and out of the airspace and upon arrival at or departure from the designated airport. So this efficiency is realized through the establishment and application of laws relating to entry and departure clearance for flights, immigration, customs, border control, and quarantine. ICAO's role, together with that of the member states, is to ensure that there is a high degree of uniformity in regulations, procedures, and organization. Annex 17 has a definition for aviation security, I think, and so does Annex 19 for safety, but Annex 9 doesn't have a definition for facilitation, but there is a formal definition for facilitation that you'll find in the facilitation manual, which is guidance prepared by ICAO. And in that manual, it is stated that facilitation refers to activities in connection with the clearance of aircraft, people, and goods through the formalities at international borders and the standards and regulations developed for that purpose. In effect, the aircraft, what does this mean in effect? That the aircraft must be authorized to fly across international borders. There should be formalities for people, cargo and goods to enter. The rules should be in place to deal with inadmissible persons, deportees, and even people who have lost their travel documents. There must be infrastructure and facilities to handle the entry and processing of goods and persons. There must be alternative places to land if the designated international airport is not available for some reason. And there must be a seamless border management through the use of passenger data. And it must also be ensured that air transport does not become a means for spreading communicable diseases and trafficking in people or wildlife species. All agencies involved must be equipped with the means to administer regulations relating to those activities. And that introduces us to who are the stakeholders in facilitation. As you've just heard, it covers a wide range of disciplines across multiple government agencies or departments that are responsible for the implementation of the facilitation legal framework. In addition to civil aviation administrations and regulators, you have national border control agencies, police, immigration, customs, animal and plant quarantine. You also have industry actors such as the airlines, air operators, airports, cargo handling organizations that also have a role to play to comply and minimize operational costs as well as delays and also avoid congestion. To those operating stakeholders, I would add tourism and travel firms. As you may be aware, 50% of tourists travel by air. There must be a high degree of cooperation among these players to ensure continuous improvement of control processes. Having gone at length about describing the facilitation environment, I'm curious at this point to ask if you could please raise your hand if your work involves or is connected to facilitation. I can hardly see any hands raised. So I should stop here because nobody, okay. Okay. Okay, a couple of you are involved. I should say as well that for those that are not, facilitation also probably concerns you as a passenger. Those of you who came here by air. Passengers as well should cooperate in improving facilitation by making themselves familiar with the regulations and complying with them. You should not, for example, be showing up at an airport without a visa or electronic travel authorization or other requirements. You slow down the process because of that. So this is the legal framework for facilitation. The Chicago Convention, of course, and the key provision appears in Article 22, where states are obliged to adopt all practical measures to facilitate and expedite navigation by aircraft and prevent unnecessary delays, especially in the administration of laws relating to immigration and quarantine. So ICAO then adopts the standards and recommended practices, the SARPs, and formulates policies and guidance material to support this process. There were originally 89 SARPs in the first edition of Annex 9, which have now grown to 442 SARPs in the 16th edition of Annex 9. You heard all this from the Honorable Minister from Malawi last night at the dinner about the evolution of Annex 9. And just to recap, it was in 1947 that the Council established the Air Transport Committee with a mandate to make proposals for standards and recommended practices relating to air transport. And thereafter, in 1949, the first edition was adopted. Some of the other significant, there have been 16 editions of Annex 9, so some of the significant additions are highlighted on this slide. beginning with, in 1982, the addition of provisions relating to national facilitation programs and national and airport facilitation committees, which bring together stakeholders to achieve the objective of easing processes. And then in 2005, the 12th edition introduced provisions on machine-readable travel documents, or MRTDs, biometric technologies, travel documents, and also assistance to accident aircraft victims. And then in 2018, we had provisions relating to advanced passenger information and automated border control systems. Most recently, the 16th edition updated provisions on public health emergencies, health proof documents, relief and repatriation flights, which were added in the wake of the COVID-19 pandemic, and also provisions on facilitation of persons with disabilities, and measures on trafficking of persons were also added, as well as provisions on passenger name record and PNR data, and the ICAO Public Key Directory, known as PKD. Chicago Convention. So the mandate for all that is done in the realm of facilitation derives its authority from the Chicago Convention, and there are as many as 10 provisions in the convention that directly impact facilitation. And to cite some of the main ones, they're all there, but I should say the central provisions are Articles 22 and 23, and under Article 22 concerns the facilitation of border control formalities, which I just mentioned, obliges contracting states to prevent unnecessary delays in air travel. And in Article 23, the states undertake to establish customs and immigration procedures in accordance with the practices established pursuant to the convention. And this is the enabling provision for the development of standards in those areas. In Article 37 and 38, the organization adopts recommended practices which states are obliged to transpose standards into their national legislation, unless, of course, they file a difference. And then going to Annex 9 itself, it elaborates the measures and practices that states must introduce for facilitation. And when you look at this arrangement, it almost follows the trajectory of a flight, beginning with the aircraft entering into national airspace at the top left-hand corner. It lands at a designated airport. Passengers disembark with their hand luggage. Checked luggage is removed and transferred for processing in the terminal. Unaccompanied bags and cargo are taken to the warehouse for processing and clearance. Special categories of passengers, deportees, inadmissible persons, are isolated for special handling. And while in the terminal, you have facilities and services for inbound, outbound, and transit passengers, immigration, public health, and customs clearance. There are also arrangements to land at an alternative place if you do not have, if there is no availability at the designated place. And also for special flights that are not regular commercial flights, such as relief flights and flights for search and rescue. And then finally, in the appendices, you have standard forms for passenger and cargo manifests, disinsection of aircraft, and crew certificates. This is not new. You heard this yesterday from my senior colleague, Mr. Verhagen, yesterday while discussing safety, about the distinction between the definition of standards and recommended practices in 18 annexes, with Annex 9 being different from all of them. You can spot the differences on that slide. On the left is the definition which applies to the 18 annexes, most of them in the realm of safety. And on the right is the definition for Annex 9. The reason being that Annex 9 is about practices and processes, and so the definition avoids using terminologies that would relate to mechanical or tangible objects. Another element to look out for is the relationship between facilitation and aviation security. Long processing times are often attributed to the application of security controls. Some have said that there is a need to balance facilitation with security, and some of these provisions appear to suggest that some kind of balancing act is being attempted, but the reality is that aviation security and facilitation are not competing fields. They are related fields, but not competing fields. They share the same objective of speedy and efficient processing for on-time departures. Aviation security, on the one hand, ensures that there is no unlawful interference with the safety of the flight, while facilitation ensures that the right people with the right credentials get onto the aircraft. There's plenty of guidance from ICAO. Those are examples of that on various topics that we have talked about. I also wanted to touch on facilitation in emergencies to say that the requirement for facilitation is not eliminated when there's an unusual or extraordinary occurrence which affects the regular and normal air transport operations. When there's a hijacking, or there's a bomb threat, or an aircraft diversion, the legal framework maintains the requirement for states to facilitate the affected flights. And the treaties on this slide cover such situation where a flight has been diverted, and the continuing theme is that measures must be taken to avoid unnecessary delays and allow the passengers to continue on their journey. That's just an example of unruly and standards on unruly and disruptive passengers, and I won't say very much there because I have a colleague who is going to speak about this later, only to note that if a flight has got to be diverted to disembark a disruptive passenger, it's an unexpected flight, and therefore needs to be facilitation needs to be provided on a priority basis, provide a landing slot, gate access, and agencies such as law enforcement to be on hand to take delivery of the disembarked passenger. These are specific subjects in facilitation. I'll just highlight one or two of them in the forthcoming slides. Assistance to accident victims. International flights, as you know, often carry passengers from many different nationalities. And in the event of an accident in one state, family members may need to travel to an aircraft accident site, a hospital, or other location in the state of occurrence on an urgent basis and without prior preparation of normal entry requirements, and standard 8.42 addresses the need to facilitate such travel. Trafficking in persons is another topic, because aviation personnel at airports or on an aircraft can be the first or last line of defense against the transportation by air of victims of this kind of trafficking. So empowering them to recognize a potential victim or perpetrator and alert authorities expeditiously is a powerful tool that can be deployed to stop these acts. And this is still a recommended practice. In time, it will grow to become a standard. but there's plenty of guidance on this issue. These are some of the risks I've identified to facilitation in the sense that these kinds of events often disrupt normal arrangements for facilitation of travel, but in spite of their occurrence, they shouldn't impact on facilitative processes. Instead, steps should be taken to introduce rational controls. And Chapter 1 of Annex 9 in particular highlights that states should take all necessary measures to ensure that minimum time and inconvenience is caused by the application of control requirements. And this applies even when these events occur. Finally, as you have heard, 2024 is designated by ICAO as the year of facilitation, and there is an ICAO Facilitation Global Summit taking place in Riyadh, in the Kingdom of Saudi Arabia, on the 21st and 22nd May under the theme Past, Present, and Future, 75 Years of Enabling Air Travel. The summit will focus on how to enhance the passenger experience through the effective implementation of several Annex 9 provisions. It will raise awareness about the regulatory framework for facilitation and highlight future opportunities such as building resilience for public health risks in aviation, and highlight the benefits of using digital representation for safe and secure movement of travelers. And will also call for priorities to be given to existing or new activities that enhance the passenger experience. So please take the messages we share today here with you to Riyadh and beyond for the cause of air transport facilitation and economic development. I thank you.
Thank you, Andrew, for your insightful presentation. I think you have clearly demonstrated that facilitation is really a cross-domain to all other subsectors in aviation, outlining how important is the legal framework in implementing in its implementation, let's say. But I think we will go back to this item later on, probably during our Q&A session. I think it's time to welcome Leslie McIntosh, Corporate Secretary and Acting General Counsel of IATA. Leslie has, in addition to a legal knowledge and expertise, a significant management experience in governance with strategic planning, organizational change, performance, and project management. She has been practicing aviation law since she joined the New Zealand Civil Aviation Authority in 1996 and has represented New Zealand and IATA in various international fora, including ICAO Legal Committee meetings, task forces, and ICAO assemblies. Please, Leslie, the floor is yours.
Thank you very much for that wonderful introduction. And I wanted to start off by extending my thanks to ICAO and the Ministry of Land, Infrastructure and Transport for inviting me to come. And we really appreciate the opportunity to present an industry perspective on an area that is very important to us and very linked to facilitation. Thank you. Is that better? As Andrew was talking and listing all the areas where facilitation is important, where there are SARPs involved, I'm thinking of what I'm about to talk about, which is about data protection and data privacy, and which is fundamentally about the protection of personal information. And in that list, if you could think about all the times that you would have to use or collect personal information in that list, and that is really the topic of that we're talking about now. I'm going to talk about some emerging issues that airlines are facing and why these are important to our members and why many of our privacy experts in our airlines are facing sleepless nights at the moment, and why we are bringing these to ICAO, to aviation legal professionals and privacy legal experts to try and find some answers to these problems. But before I get into the substantive part of the presentation, I want to emphasize that airlines, of course, recognize the need to protect personal data. We work fervently to comply, and we're not asking for airlines to be able to opt out of these important compliance requirements, but we need some consistency and we need some recognition of the special characteristics of civil aviation in the context of those. So I'm going to talk about the use of personal data for the physical transport of passengers and goods, not for the sales and marketing efforts that our airlines do. And I think that's an important distinction. Airlines aren't asking to be exempt from those regulations that apply to all areas of commerce at the moment. So this is a good look at the kind of data to think about. It's an iceberg. Above the waterline, these are the data that governments understand. It's information that's requested. It's API, PNR, health data, as we saw in COVID. Those are things we know about. There are other things above that line that maybe are emerging. We're working with the Legal Bureau and the Legal Committee on the Article 12 Task Force, which talks about information about offenses, which will include personal information that airlines will need to disclose for the purpose of collecting information about offenses. Below the waterline is a raft of other data that needs to be transferred. Airlines face a difficult situation. For example, a baggage handling contract might be 60 pages to protect bag tag numbers, which is personal information. There's 20 pages for EU data transfer clauses, 15 for the UK, 12 for China, 9 for Brazil, and 4 pages for the contract. So most of the contract is about protecting personal data in order to comply with different rules all around the world. So we haven't been to date really looking holistically about how the aviation regulatory framework and our obligations under the Chicago Convention interact with national data protection law. So what are the special characteristics of civil aviation that require us to look harder at this? Firstly, international data transfers are essential to the physical transport of passengers and goods across borders. Complex travel itineraries through different types of booking methods, both with the same carrier and with interline, all recognized as essential under our facilitation activities, result in different regimes applying. There is a requirement to transfer data in accordance with international obligations and the SARPs. An airline is a single entity operating in all states. That's a requirement under ASAs and also a requirement under the aviation regulatory system and AOCs. You can't have different legal entities operating under one AOC. The booking process requires a single database. It's not split between different locations. All these elements are things that come into question when applying data privacy laws and data protection laws. It's also worth remembering that most of these laws were in response to a rise in social media and e-commerce. They didn't consider the unique or special characteristics of international civil aviation, and what does this mean in the context of data protection. it is very unique that we physically transport both the subject of the data, the personal data, from one jurisdiction to another, and that data. The transfer of data is required in order to conduct air transport. So as you can see that there are a number of, there's 3/4 of all states have some kind of data protection regulation. And yes, this has been happening over some time. And you might be saying, well, why are we bringing this to the attention now? It's because the issues are becoming sharper. The pandemic brought to light the importance of health information, which is considered sensitive information under many privacy regimes. And there is also an increasing enforcement of privacy laws. A big sharp issue that our airlines are facing is the requirements of the EU with respect to transferring data from one state to another, and the conflict between that requirement and the PNR issue. Data protection laws apply in almost every state. National or regional laws are inconsistent with each other. There are different concepts in some of the laws. The GDPR has concepts that are not apparent in other jurisdictions, and it's really necessary that we get some consistency so that there is a seamless ability to protect privacy as people travel across jurisdictions. The EU is this adequacy issue. So there is a requirement that when data is transferred into another state, the EU has an adequacy assessment to make over the laws of the other country. And there has been some issues, sharp issues, just in the last few months about this adequacy issue and the requirement to transfer PNR data, which I'll get to in a moment. Just to give an example, what data protections would apply in this situation? We've got Mary, who is a citizen of Canada, and she's traveling around Europe. And she books a flight departing from Spain to Brazil. The booking is to travel on an airline based in the US. Which data privacy or protection laws might apply to Mary? Is it the EU because she's in the EU? Is it Canada because she's a citizen of Canada? Is it Brazil because that's where she's going? Or is it the US? And what happens if the EU does not permit the sharing of PNR data with Brazil, where she's going? What happens then? How does an airline comply? Other considerations. There's often talk about the legal basis for processing personal information. That legal basis then gives an entity a reason to do so and can allow an entity to do so without offending the laws. The problem is that there are conflicting legal bases in most jurisdictions, in some jurisdictions. It's not just a conflicting legal base, it's a totally different concept. In the EU, you might have a legitimate purpose in doing it, but in some places, you have to have express consent every time. So there's a conflict. What does an airline do in transferring passengers? So I'm going to give another example, sharp example, but could be real. Our passenger is John. He's traveling from Calgary, Canada, to Algeria, and he's going through France to do so. He has cerebral palsy and requires a wheelchair and assistance throughout the duration of his travel. He has a Canadian airline on the first leg. He changes airlines in France, and then he lands in Algeria. The legal basis for the collection, processing, and international transfer, varies between all three of those jurisdictions. And he also has sensitive information that must be transferred, that is his health information, all of which is required to be transferred in order to facilitate his travel. So it causes a problem for our airlines as they are dealing with this information. What jurisdiction do they comply with? How can they possibly comply with all of them? Is there a way that we can ensure that there is some consistency or ability for this to happen without coming into a compliance situation? Now the sharp issue, PNR implementation. So there are, at the moment, there are almost 70, I think 68 countries that have PNR implemented. In 2018, there were only 25 states. So you can see that it's becoming sharper and sharper. And it will continue to grow as it's now a requirement under Annex 9. Under GDPR, there is a legal obligation that a third country is not recognized as it's not recognized as a justification to transfer information just because it's required, just because there's a legal obligation to do it. It needs to be to a country with adequate protection of personal data. And there has to be an assessment made that there is such adequate protection, and then there has to be a bilateral between those countries to do that. So this causes issues where third countries request PNR, they're obligated to do so, they're requiring it to do so. However, European carriers cannot comply. So what happens? There are situations where airlines are subject to fines. There's even threats of removing operating approvals under ASAs. There's a conflict between the ASA, which grants those rights, and the privacy laws. Is that discrimination? This will only get worse. To date, third countries have generally tolerated the situation, but there is a trend coming where, in fact, airlines are being fined for not complying with the PNR directive. And that is an issue that we are really noticing and causing a lot of difficulties. We've been made aware of one Gulf state that has insisted that all airlines provide PNR data in line with its laws, as it should, because that's a compliance issue. The penalties are equivalent to $50,000 per flight for non-compliance. And the Ministry of Foreign Affairs in that airline's home state is trying to get involved in making representations that this shouldn't happen. But what do we do now? We know of one member airline that was recommencing services in that same Gulf state and was threatened with the removal of route operating approvals because PNR data could not be provided because it would have been contrary to the laws of the home country of that airline. And that's despite the fact that there is an ASA governing it. So it's a huge difficulty. It's becoming more and more a difficulty. So what can we do? What can we do? What have we done to raise awareness of this issue, and what are we suggesting is a legal potential avenue to look at? So last September, we held a joint seminar with ICAO, and this seminar was incredibly successful. 200 attendees gathered to talk about the conflicting issues of data protection and civil aviation. It was attended by council members, privacy experts from airlines, CAAs, international organizations like the OECD and the Pilots Association. And it quickly, throughout the day of that seminar and in the discussions that have happened since, that things need to be set in motion. And that's how we've now come to develop a white paper. And I had hoped that it would be ready by now, but it's not quite yet. IATA has a group of privacy law experts within legal departments of airlines called our Privacy Law Working Group, and they have been working on this in connection with some experts from law firms and from other organizations. And it's about to be ready for release within the next couple of weeks. And it will focus on how the airlines feel this issue. What are the sharp issues for the airlines? What are the solutions that we think might become useful? The paper illustrates how airlines handle personal data, collecting, processing, retaining, and transferring it to other states and aviation stakeholders. And this includes examples of the challenges that are faced. In addition, we will demonstrate how important it is to recognize the special characteristics of international civil aviation, and we need to take these factors into account when assessing new privacy laws in particular. One of the issues, PNR, and how that can be managed is something that is discussed in the paper. And we've also done a review of the conflicting legal bases that I highlighted just very briefly, and how airlines have been handling these challenges. There's one example that will be focused on that I haven't mentioned, and that is data localization. And that is the requirement that data be processed in the jurisdiction of either the subject of the data or where the data originates from. And it makes operations very complicated. As I mentioned before, airlines can't be incorporated or have separate legal entities set up in each jurisdiction. It's a cost issue, but it's also a regulatory issue for airlines. So when data is localized, it can slow down processing times, affects decisions for flight planning and customer service. Cross-border data flow restrictions make international operations like booking, ticketing, and loyalty programs more challenging. Airlines are being put in a position where they potentially face huge penalties, even if compliance with one country's law may infringe the laws of another country. I'm running out of time, so I'm going to skip my other comments on the white paper just to say that it will be available very soon. Really, the purpose of the white paper is to think of a way forward. The issues are complex. There is a lot of discussions to be had. We think that other multilateral initiatives that are underway in the OECD, for example, might help with this issue. We think that it's important to have a multidisciplinary group to assess what solutions could be adopted for civil aviation. And we firmly believe that some guidance would be helpful. We're not advocating that there is an international instrument on this, but guidance material as a way to move forward on this. So I am almost run out of time, but I do want to stress that this is what we think would happen. We would think that working through ICAO with our assistance, with the OECD's assistance, and with some privacy experts' assistance, that we might be able to develop some high-level guidance material that might help states and airlines in complying with data privacy and in developing data privacy regulations. So thank you. I've run out of time.
Thank you, Leslie. Your presentation was really helpful in, in understanding the various legal implications in transferring personal data from one jurisdiction to another, especially when it comes to PRM, which are really increasing in their numbers, changing the shape of air transport nowadays. Before going to the next speaker, just one clarification from my side. Some of the slides presented by Leslie will be used also by Erica in her presentation later on, if I understand correctly. Please.
New slides.
New slide. Okay, okay. Now, let's welcome Ms. Young-Ju Cho, partner attorney at law, Lee and Co., which is one of the biggest law firm in Korea. In recognition of his distinguished service, Young-Ju received a Minister Commended Man of Merit Award by the Ministry of Land, Infrastructure and Transport. In fact, in addition to his practice on aviation regulations, including new areas in drone urban air mobility regulation, MAA, cross-border investment, and drafting various contracts, he has handled complex matters representing numerous foreign airlines in achieving permission for foreign international transportation service in Korea and offering legal advice to foreign and domestic airlines regarding any issue related to aviation regulations. Please, Young-Ju, the floor is yours.
Thank you again for inviting me to the ICAO conference legal seminar. This has been, I think, the third time I'm making a presentation here, and I'm again very honored to be part of this seminar. Now, I will try not to overlap any issues that Leslie presented. The data privacy laws conflicting in each jurisdictions right now here in the world is a major issue, especially the GDPR and the PNR issue is also a critical issue right now here in Korea. So the question is now, what I'll try to do is, so not to overlap with Leslie, is try to be focused mainly on the Korean law, Korean data privacy law, especially in the field of aviation. So as Leslie has pointed out, you know, there is enhanced personal data protection regulations, and the aviation sector faces challenges due to conflicting regulations across countries. And this complexity arises due to the sector's unique feature. As you know, wherein individuals from various nations are information principals subject to diverse data protection frameworks. So currently, the significance of safeguarding data and personal information cannot be overstated. However, you know, the laws of each state conflict each other, and blending personal data protection regulations from different states. So these regulations frequently do not align with each other, causing difficulties. Let's try to at least understand the main issues here under Korean law. What I'll try to do is briefly explain you the major concepts in the Korean Personal Information Protection Act, and how the regulations, how it's processed, and then some cases here, majorly here under Korean law. So the major concept would be, of course, number one, what is personal information? Now, a personal information is an information of a living individual. And a personal information must identify a particular individual by his or her full name, or it could be a social security number, even a picture. And even an information that could be easily combined with other information to uniquely identify an individual that could also be regarded as personal information. So in cases, whether or not there's an ease of combination, that's a determination, reasonably considering time and cost, technology, used to identify an individual, that would be how you distinguish the easily combination. And there's also a concept of pseudonymized information. And in most jurisdictions, pseudonymized information is personal information. In some jurisdictions, they are not. And pseudonymized information is information information incapable of uniquely identifying as an individual without the use or combination of information for restoration. But they are still regarded as personal information, whereas anonymized information under Korean law is not personal information, no longer capable of identifying an individual, even if additional information used. We are of the understanding that EU, US, China also does not regard anonymized information as personal information, but in some jurisdictions, we wonder they do. And again, it's a living individual information, so information about a deceased person, corporate entity, organization, corporation, that's not personal information. And there are issues about behavioral information and ADID. The Korean Personal Information Protection Committee, the PIPC, has not yet made a conclusive opinion, but we would have to review those issues. And there's the concept of personal information controller. Then what is a personal information controller? It's a legal entity that processes personal information for the purpose of its work. Then what's the purpose of its work? Of course, excludes personal activities, private relationship. However, if you have an intent and continue, then whether the processing was done a single time doesn't matter. The intention is important. Then what are personal information files? Those are sets of personal information arranged or organized in systematic manner based on certain rules of search. But like one-time note-taking or documentation, those are not regarded as processing personal information files. There are some concepts to distinguish. One would be personal information handler, and another would be personal information processing industry. We will not go over these since we are, I should be running out of time. And there are some regulations under Korean law that protect personal information even more. One is Credit Information Use and Protection Act, and credit information is even protected more hardly than personal information. And then there is an act on the protection and use of location information. Location information here in Korea, you need a business license to conduct a business using location information. Then step-by-step issues in personal information processing. So the main issue is, of course, collecting and using. How do you collect and use personal information? The principle is, of course, number one, consent. And you must even notify in advance. And if any of the notified information is changed, notify again and obtain consent again. And also, you cannot use that information outside purpose use. And of course, there are exceptions for major airlines. Fortunately, not only where there's a law in Korea to comply with the legal obligation, not even that, but where necessary to fulfill a contract or take steps at the request of the data subject, that is also an exception in Korea. So let's say you want to implement an employment agreement, you want to implement the air services, air purchase agreement with the customer, then there's some exception here under Korean law. However, these, of course, exceptions are existing on a very limited basis. Then there are third-party provisions and processing entrustments. So third-party provision is providing that personal information to a third party. Again, you need consent. And these consent is a separate consent from the consent to use and collect personal information. So you need to have a separate consent. Of course, there are exceptions. Again, if there is a special provision in the law, or if it's necessary to comply with the legal obligation, then there's an exception. In case of international air transportation, fortunately under Korean law, the Immigration Control Act that requesting for the passenger reservation that are PNR, And also the Aviation Security Act, it does search, give grounds processing personal information. So there are some laws in Korea that, let's provide those personal information to a third party. Again, purposes of providing that purposes other than which has received consent requires, of course, separate consent. And there is a concept that should be, to be noteworthy, which is third-party provision and processing entrustment. The processing entrustment is something different from just providing personal information. It's just processing entrustment. Again, this is different because it does not require prior consent. And it is similar to a third-party provision in a sense that personal information is transferred to a third party, but third-party provision is for the business processing and interests of the recipient, whereas processing entrustment is for the business processing and interests of the personal information controller. So that's the main difference. Entering into a personal information processing entrustment agreement and disclosing that entrusted task is needed, and that would be the significant difference. And most airlines have to deal with the cross-border transfer of personal information. Meaning of cross-border transfer, I think you all know what it means. Then what are the requirements? Of course, a separate consent is needed. Again, if you have a consent, then in most jurisdictions, if you have a separate consent, then that is normally okay. Whether there are exceptions. Exception applies where certain cross-border transfer is necessary for execution or performance of contracts on the premise that the above notification items has been disclosed, of course, to the person. And here in Korea, cross-border transfer is permitted where it is recognized that personal information protection system of the country or international organization to which the personal information is to be transferred is substantially equivalent to the Personal Information Protection Act of Korea. So Korea jurisdiction tries to allow cross-border transfer even without consent if they regard that personal information is substantially being protected in that other jurisdiction. However, the Korea government has not yet recognized any other government body yet, but we'll have to see. And this is, I think, a big development under Korean law in terms of data protection in aviation. Then destroying personal information, even destroying personal information, there's a law for that. When can you destroy it? Expiry, of course, or like canceling a membership. And there are, under Korean law, like, for example, the labor law says for 3 years, in 3 years you have to, destroy it. And again, you have to destroy in a form that cannot be restored or reproduced again. Then there is leakage. Leakage is a concept that happens, and then how should you react? You have to notify within 72 hours. If the data subjects whose contact information is known must post it on the website at least for 30 days. And report it to the Personal Information Protection Committee or the Korea Internet and Security Agency within 72 hours. And those are the two obligations. And the sanctions, the potential sanctions, when you look at them, number one, investigate. There could be an investigation. And then fines and penalties may be imposed. You can see the fines here. They are 3% of total revenue minus revenue not related to the violation. So there was a case, a penalty of even $750,000 US. So it's not really a small amount. And the causal link between the violation of the law and the personal information leakages doesn't have to be even established. So you do not have to, the person does not have to prove there has been a casual link, and then ask for damages. And there's even criminal punishment here under Korean law. So then what is the issue with airlines in Korea? Fortunately, no cases yet confirmed in which the Korean authority imposed penalties on airlines. The PIPC did discuss with the aviation industry officials on ways how to strengthen the level of personal information protections. That was last year around November. Well, fortunately, the aviation industry, particularly emphasizing on restrictions, processing on sensitive information and unique identification information, compliance with PIPA was really discussed, and how to provide those personal information overseas. The PIPA did mention, though, that the airline, if without consent processes sensitive information to a third party, then the airline may be subject to the person in charge of the airline may be subject to imprisonment of 5 years and or less, or fine up to 50 million Korean won. Also, there's a penalty of 3% of its total sales, excluding of course sales that are not related to the violation, which we have seen earlier. And then another 30 million Korean fine could be levied. So this is not an easy issue, and but unfortunately until now there are no cases of Korean authority actually harshly implementing it to foreign airlines yet. Let's look at some very I should say interesting funny cases. So there has even been a prison term for an unauthorized sale of personal information. It was in 2020. Somebody sold personal information and in exchange for money, so 1 year and 6 months of imprisonment, and another fine for approximately 301 million Korean won. That would be $224,000 US. And is a last 4 digit of a mobile number. So there was an issue, police, the last 4 digit of mobile phone number that was leaked, is that a personal information or not? The court ruled it can be easily combined with other relevant information, and then it is a personal information. So you can see how strict the Korean court regards personal information. And then a photograph, a portrait or likeness of a person. It was just a photograph with a cover letter. That is also regarded by the court of personal information. And then phone call records acquired during police investigation. Phone call records are also regarded personal information under Korean law, and that's how the Korean court sees it. Now, these are not really important issues. There are some amendments which could be a burden to airlines and the airline industry. Number one would be expanded imposition of penalties. So there could be much higher penalties in the future because the changed basis for calculating penalties from revenue related to the violation to total revenue. So the total revenue is a much larger concept compared to the revenue related to the violation. So this could become a burden, of course, for a lot of airlines. And also, when obtaining consent to the processing of personal information, now the amended Korean law must allow the data subjects to freely decide whether to consent or not. Because before there was kind of a practice that even if that person did not consent, grant consent, it could be regarded as mandating consent. But that practice cannot be regarded anymore here in Korea. So also Korea is creating a right of data subjects to request a personal information controllers over a certain size to transfer personal information. So these are also some new regulation you can consider here under Korean law. So I have like 1 minute left. Just so one thing, just again, for the airline industry, there are conflicting jurisdictions, but again, under Korean law, there could be an imprisonment and even a penalty up to 3% of the total sales, and a fine again. And it's not just for providing that personal information, it's for not having received consent, not having processed it correctly, not having entrusted it correctly. They are all separately regulated, and so airlines and the airline industry should be all aware of it. And as Leslie has pointed out, the international community really needs some kind of a universal regulation to, so that no conflicts between jurisdictions occur. Thank you.
Thank you, Young-Ju, for sharing your expertise. It would be interesting to explore relation between data collection and artificial intelligence, because I think that if it could be useful, of course, in analyzing data, probably it's not too easy to be implemented in all jurisdictions, but we will come back to it if we will have time later on. Now, in conclusion, let's welcome Erika Varga. Erika is legal officer from the Legal Affairs and External Bureau of ICAO. Erika has a law master degree from the University Health in Budapest. From 2013 until her secondment to ICAO, she served as legal advisor in the DGCA head of the CAA of Hungary and Deputy Director General, and joined in 2007 the CAA of Hungary, working in different positions, lawyer at the legal department, and supporting the function of CAA. Please, Erika, the floor is yours. But of course, first of all, Leslie, for introducing some slides.
Thank you, and thank you for your patience. Just quickly, I wanted to share some data, the most up-to-date data on unruly passengers. And I think our concern is that there is a growing frequency and severity of the unruly and disruptive passenger behavior on aircraft, and it's a concern to everyone. This data that I'm showing is the 2023 data that is relatively new and raw, so there's some analysis that needs to be done, but I think it's useful to show it in the meantime. So I'm just trying to push next, yes. So essentially it's clear that there are, it is rising. We have reports from 60 airlines. IATA has over 320 members, so you might say 60 is not representative, but we've kind of extracted based on what we've got. It seems to indicate that there's approximately 25,000 event reports from just 57 operators. So if you extrapolated that, it looks at a rate per 1,000 flights, and it's about one incident for each 480 flights in 2023 versus one incident for 568 flights in 2022, with about the same number of airlines reporting. So it indicates that it's rising. And I suppose the other thing is that not all incidents result in violence. Diving a little bit deeper into the data shows the kinds of indicators that we ask our reporters to classify. So generally, what I think is remarkable from this slide is that non-compliance is indicated at a really high level, increasing a lot in 2023. That non-compliance includes a number of things. It might include things that as from not wearing seat belts to not putting electronics away to smoking in laboratories, and so it's an increasing. While this doesn't necessarily mean that there's violence or abusive behavior, I think there are a number of incidents in that list that in fact do show a trend that that kind of behavior is also increasing. In 2023, physically abusive cases occurred in every 6,024 flights versus in 2022, every 17,240 flights. So it's quite an increase. So I just wanted to share those slides. And of course, Erica's going to talk a little bit more about what we can do about that. Thank you.
Good morning, ladies and gentlemen. Thank you very much, Leslie, for this very valuable introduction. I think it is very important to see the industry's perspective and the industry's data to understand better why it is so important for us to do something on unruly passengers. My topic today is basically the role of the Montreal Protocol 2014 in dealing with unruly and disruptive passengers. As we heard yesterday, the Montreal Protocol is one of the key air law treaties which will be promoted by ICAO. And actually, amongst these 6 key ILO treaties, the Montreal Protocol has the lowest ratification rate until today. So on one hand, as Leslie introduced, we see a rising number of disruptive and unruly passengers, which is a major safety issue. But on the other hand, we have, unfortunately, a pretty low ratification rate of the Montreal Protocol. So in my presentation today, I will try to highlight the achievements of the Montreal Protocol, why this is beneficial for the whole aviation community. And at the same time, we are trying to promote the ratification of the Montreal Protocol, of course. So if we look into the status of the Montreal Protocol, then we see that the protocol is amending the Convention on Offenses and Certain Other Acts committed on board of aircraft, which was signed in Tokyo in 1963. The protocol was done in Montreal on 4th of April 2014. We are just a few days after the 10th anniversary of this protocol, so this is another occasion actually to talk about this important legal instrument, and it is already in force since the 1st of January 2020. Currently, 47 states are parties of the protocol, and just to comparison, the Tokyo Convention has 187 parties for today. So this is the original convention which has been amended by the Montreal Protocol. So a bit about the Tokyo Convention. I am sure that most of you are familiar with the Tokyo Convention. So the Tokyo Convention applies to acts which may or do jeopardize safety of aircraft or persons or property therein, or good order and discipline on board. It is commonly agreed that this interpretation includes unruly and disruptive behavior as well, even if this expression does not appear in the Tokyo Convention as such. So even if this is not defined in the Tokyo Convention, this is a common agreement in the aviation community that we understand this as unruly and disruptive behavior as well. The state of registration is competent to exercise jurisdiction, and establishment of necessary jurisdiction is required by the states who ratified the convention. And moreover, this convention contains detailed rules for the power of the aircraft commander as well. So having said so, I want to look through a few reasons which were reasons for the modernization of this Tokyo Convention. So as we heard earlier, there is an increasing number of incidents of unruly and disruptive passenger events. I would like here to mention that we do not have any uniform reporting system. So as Leslie mentioned earlier, they are collecting data from their air carriers, but this is not a representative data collection because there is no reporting system. To my best knowledge, nowhere in the world exists such a reporting system which is focusing expressively on these unruly disruptive passenger events. So we don't really have the absolute appropriate data to deal with it. Another reason for modernization was that there are different laws and jurisdictions which are applicable. So it means that one specific behavior can be regarded in one state as offense, and in other state it is not an offense. So the thinking behind that was that it is very useful to have a harmonized list of offenses which could serve as a common framework of reference for all the states. Additionally, international conventions in aviation security are designed for particularly serious offenses such as sabotage and hijacking, and they are not specifically designed for less serious types of offenses or acts such as disruptive or unruly behavior of passengers. So the mixture of all these circumstances led basically to insufficient enforcement actions, even if this problem is raising and is a potential threat to aviation safety during the day-by-day operation. So what I would try, that I am trying just to highlight the main achievements of the protocols. These are the advantages what we can use if the countries are applying this protocol. So one of the main achievements is the extended jurisdiction. Jurisdiction is a main problem concerning the basic agreement. So while the Tokyo Convention requires the states of registry to establish appropriate jurisdiction over offenses committed on board of aircraft, the Montreal Protocol additionally requires the state of landing and the state of operator as well to establish appropriate jurisdiction. And additional to the state of registry, the state of landing and the state of operator have competencies also to exercise jurisdiction over offenses and acts committed on board. I just would like to highlight a distinction here between establishing appropriate jurisdiction, which is an obligation, and having competent or having the competency for exercising jurisdiction, which is a competence here. So there are two different things what we are talking here about. These are competing jurisdictions. I am fully aware that many countries have some concerns about, because just typically it is competing jurisdiction can be confusing. So it means that we have several states, several countries which can have competencies in jurisdictions. But the Montreal Protocol says, because of this, that states exercising jurisdiction shall coordinate with other states in case if there is information that other states conduct proceeding, investigations, or prosecutions in respect of the same act. So there is a coordination obligation amongst the states which could have possibly jurisdiction. Having said so, I just would like to show you a very simple example, operational example, just to understand maybe a bit better what's the difference between the Montreal Protocol and the Tokyo Convention. So we have country A, country B, and country C. Country A is state of registry, country B is state of operator and state of the destination, and country C is the state of landing, actually. So if there is an unruly passenger on board, which endangers safety, then the pilot in command can decide to return to country A. So returning to country A, that's the easiest way, return to the state of registry. Even under Tokyo Convention, so when we are talking about that these states, neither A, B, C states, they did not ratify the Montreal Protocol, so we are under the Tokyo Convention. Even in this case, if the flight return with the unruly passenger on board to country A, there is no problem, because country A, the state of registry, has jurisdiction, so they can make the appropriate enforcement action. In case, if the pilot decides to continue the journey and not to return to the origin, but land in country B, as it was planned originally, then there is a problem, because we have an unruly passenger on board, landed in country B, And maybe police forces or local forces can make protocols, can make some enforcement actions, but actually the competence of jurisdiction is not at country B, is it at country A. The same problem appears if the flight is diverted because of this unruly behavior. So the pilot in command decides not to land in country B, but just to land in country C at an alternate airport. And based on the Tokyo Convention, the country C does not have any jurisdiction over this passenger, so that's again problematic. If these countries ratifying the Montreal Protocol, it would mean that all these 3 countries would have jurisdiction over this behavior, over this unruly passenger, which makes it much more easier to have appropriate enforcement actions. So basically, this is the very simple example just to explain the difference if a state ratified the Montreal Protocol or not, and using the Tokyo Convention on this. Sanctions. There is another achievement that serious offenses are usually subject in national legislations of criminal prosecutions. But if you look at disruptive and unruly behavior, this is, in contrary, often punished with civil and administrative sanctions, depending, of course, on the seriousness of the specific act. But this is mostly not a subject of criminal prosecution. So now there is a very common principle that sanctions should be efficient and effective against unruly and disruptive behavior, and it depends, of course, on the seriousness. There is a wide range of sanctions applicable, and there are to the discretion of the countries to decide which sanctions they apply based on their own sanction system. The Montreal Protocol does not prescribe any type of penalties or sanctions. There is a range of options for that, but there is an ICAO manual, I will refer to this later on, which provides us certain guidance on the element, on the administrative sanctions regime, which can be used. The Montreal Protocol expressively encourages states to make necessary measures, appropriate criminal, administrative, or any other forms of legal proceeding against the person who commits on board an offense or act which we consider as disruptive or unruly. Sanction and prosecution. So in case if the state of landing is exercising jurisdiction, it shall be considered if the offense is an offense in the state of operator 2. This means that if there is an act, it's an offense which is unlawful in its jurisdiction, in the jurisdiction of the state of landing, but it is not unlawful in the state of operator, sanctioning should be exercised with caution, because multiple states can have jurisdiction. Sanctioning should be exercised with the appropriate caution. This is also an achievement of the Montreal Protocol. And finally, I would like to stress the role of the in-flight security officers, which they are called also commonly air marshals. So the Montreal Protocol extended the legal recognition of in-flight security of officers. So the Tokyo Convention basically clarified the power of the commander, and the Montreal Protocol added provisions concerning the power of the air marshals or in-flight security officers. This means that air marshals or in-flight security officers may take reasonable preventive measures without the authorization of the commander under certain circumstances on board. I just would like to mention that in-flight security officers are deployed based on multilateral or bilateral agreements, and this is still the same rule applies. So if there is multilateral agreements or bilateral agreements which apply, then in-flight security officers can be on board. Otherwise, if that's not the case, that's not applicable, of course. So the Montreal Protocol did not change anything on the existing framework of the in-flight security officers. These are the main achievements, maybe, of the Montreal Protocol, which I wanted to highlight, but there are also some additional achievements connected with the Montreal Protocol. So first of all, yesterday, we talked about definitions. Definitions are extremely important for us just to be able to understand what is for what applicable. That's generally for lawyers, legal people, definitions are the basis all the time. So I mentioned that unruly or disruptive behavior is not defined in the Tokyo Convention or in the Montreal Protocol, and there is a wide range of acts which are considered as unruly or disruptive. Commonly, we have an understanding that when we are talking about unruptive or disruptive behavior, we are referring to passengers who fail to respect the rules of conduct on board or to follow the instructions of the crew and create a threat to safety of flight, or disturb the order and discipline on board. This is our common understanding, but this is not written as a definition as such. So we do not have an exhaustive list of these acts. As we have seen during the previous years, during the pandemic, several new unruly behavior types appeared. For instance, not complying with wearing masks on board, or not complying with the social distance regulation, which have been different from state to state. But all the time, new behaviors appear, so this is very logical that we do not have an exhaustive list. However, we have DOC 10117, and in DOC 10117, we have a list of typical unruly and disruptive behavior, and this DOC has been updated to align with Montreal Protocol 2014 as well. However, as I mentioned, this is a non-exhaustive list, so states are encouraged to incorporate the list into their national legislation as far as practicable, of course. It means that this does not preclude state from establishing certain acts as subject to legal proceedings neither. There is a model legislation and guidance on administrative sanction regimes which should assist states to apply appropriately the Montreal Protocol. As I mentioned, this doc includes a model legislation on certain offenses committed on board of aircraft. This is Appendix A of this doc, and includes also a guidance for introducing an administrative sanctions regime on certain offenses committed on board aircraft, which is Appendix B of this doc. These are the main relevant documents, DOC 10034 and DOC 10117, which can be used by ratifying the Montreal Protocol. So ICAO encouraging all states to ratify this protocol in order to ensure effective and efficient enforcement actions against unruly and disruptive behavior. Thank you very much for your attention.
Thank you, Erika. It would be important to know if ICAO could take some steps in front of states, like my one, unfortunately, where it's still pending ratification process in order to convince the, let's say, between brackets, the reluctant states to ratify the convention. I think, unfortunately, we finish our time with time restriction, and unfortunately, we don't have space for questions from the audience. But my last duty would be to ask all of you to tribute a big applause to our speakers.